I'm Mark Haase, and I'm a board member of the Minnesota Justice Research Center. Thank you, Mayor Fry, for your welcome to the beautiful city of Minneapolis virtually. Thank you for your message, and thank you for the work you do on behalf of the people of Minneapolis. I have the honor of introducing you to our first keynote speaker today, Marc Levin, the Chief of Policy and Innovation for the Right on Crime Initiative at the Texas Public Policy Foundation. Mark began the Texas Public Policy Foundation's criminal justice program in 2005 and currently serves as the Chief of Policy and Innovation for the Right on Crime Initiative. This work has contributed to nationally praised policy changes that have been followed by dramatic declines in crime and incarceration in Texas. Building on this success, in 2010, Mark developed the concept for the Right on Crime Initiative, which has become the national clearinghouse for conservative criminal justice reforms. In 2014, Mark was named one of the Political 50 in the magazine's annual list of thinkers, doers, and dreamers who really matter in this age of gridlock and dysfunction. Mark also serves on the National Association of Drug Court Professionals Board of Directors, has testified before Congress and numerous state legislatures, and has met personally with leaders such as US presidents, US speakers of the House, and the Justice Committee of the United Kingdom Parliament. In 2007, he was honored in a resolution unanimously passed by the Texas House of Representatives that stated, "Mr. Levin's intellect is unparalleled and his research is impeccable." Mark has also published dozens of policy papers on topics such as sentencing, probation, parole, reentry, and overcriminalization, which are available on the website of the Texas Public Policy Foundation. His articles on law and public policy have been featured in publications such as the Wall Street Journal, USA Today. In 1999, Mr. Levin graduated with honors from the University of Texas, and in 2002, he received his JD with honors from the University of Texas School of Law. He served as a law clerk to Judge Will Garwood on the U.S. Court of Appeals for the Fifth Circuit and staff attorney at the Texas Supreme Court. An impressive resume, Mark. I've personally known Mark for a number of years now, and I consider him a friend. More importantly, he's been a good friend to Minnesota. Every time he's been asked to come here and share his experience and perspective and knowledge, he has not hesitated. Mark, this year we're going to let you stay in warm Texas as you join us. It's getting a little cold here. I want to emphasize that although Mark has been instrumental in advancing criminal justice reform advocacy by conservatives and he brings that perspective, I know him at his core to simply be an advocate for justice, and he'll work with anyone who will join him in that work. To me, he exemplifies the idea of bipartisanship that I believe we need if we're going to make sustained and significant reform on these issues. Like many of us, Mark has seen a lot of changes in the landscape on these issues over the last 15 years. And I think he would agree that never have things changed as quickly as they have in the last few years, and even just this year, 2020. So I'm looking forward to hearing his thoughts and ideas on where we're at and where we need to go from here. And I'm glad you're able to hear that as well. Mark, welcome, and thank you for answering the call once again.
Well, thank you for having me. Really appreciate the chance to be with you. And I think perhaps the best thing we could do as far as thinking about where we need to go from here is to indulge in a hypothetical that we all wish was reality, which is to say, what if George Floyd had survived that arrest and he was still with us today, and if he had gone through the justice system after that? And I think what we can learn from that is that we have to orient our system of justice around people with the most vulnerabilities and recognize that not everybody comes to the system with the same ability to navigate it. And of course, in the case of George Floyd, he had a number of health issues, including COVID, but others as well. And those place someone in greater risk, both in terms of, as we saw with arrest, and then, of course, once somebody's incarcerated. You know, just 6 days ago, a 19-year-old named Abby Rudolph, she vomited to death in the Clay County Jail in Minnesota. which is still being investigated, but just an absolute horror for her parents to have to receive that phone call. And sadly, we have deaths all around the country in our jails and prisons, both because of COVID, but also other reasons of neglect every day. But as we start to look at how do we orient our system around people with the fewest resources, the least ability to withstand certain procedures, like we saw with the officers kneeling on George Floyd's neck, somebody who has asthma, somebody who has a disability, autism. And actually, I was glad to see autism training was in the policing bill that the Minnesota legislature passed. It certainly was a good start. There's a lot more to be done. But that's an example, and we have to orient our whole system in that regard. And bail reform, which is something we're going to discuss today. The idea that someone would stay in jail simply because they don't have enough money, not because of any risk they to the public. Indigent defense, which I'll touch on as well. But these are all areas where, whether it's because somebody doesn't have money or because they have health issues, they come to the justice system more vulnerable. And, you know, in our society as a whole, we're a free market, right? We say people that have the greatest natural ability or work the hardest, they theoretically get ahead and make more money, and they can buy a nicer car and house and all of that. That's all one thing. But when it comes to access to justice, we don't just need equality, we need equity. If you have a bail schedule, that's equal, but there's no equity because people that don't have money for the same offense, for the same risk level, they're not able to get out of jail. So that's really what we need to do. You know, I was reminded of this when I was actually in a parking garage, and I saw a sign that said, "Watch out for small children." It didn't mean don't watch out for big children, but it meant that the small children are most vulnerable and you're least likely to see them, and they're least likely to be able to get out of the way. And that's what we're dealing with in the justice system. You know, obviously the issue of race is one we can't overlook. African Americans make up 19% of the Minneapolis population, but 58% of the use of force incidents. Now, obviously, sometimes use of force is necessary, but we need to have the best training. We need to have accountability so that the public has confidence in that complaints are investigated independently and with integrity. And that's really what I think is perhaps most important for us to discuss today is how do we have a system that people can trust? And there was a survey recently in Chicago that found only 30% of African-American men trust the police. More than 70% of whites said they trust the police. That's a huge problem. Beyond the just problem from a justice perspective, from a perspective, it's also a huge problem from a public safety perspective. That is, if people don't trust the police, they're not going to report crimes as witnesses, and they're not going to come forward as victims. And in fact, there was a study in Milwaukee several years ago that found that very thing. It looked at, there were a few high-profile police shootings of African-American men, and they were all over the local TV news. And after that, the study found that people were less likely to report serious crimes, all crimes, but including serious crimes, to the police in the months following that. So the only way we can actually get to a safer society is to have one where we build the bonds of trust between the police and the community. And it's actually broader than just police. It's the justice system as a whole, for example, addressing wrongful convictions, which undermines trust in the justice system. So, you know, we saw during the summer of unrest, we often saw the sign, "No justice, no peace." And, you know, the order of those things is something really important to think about. Justice takes time. And of course, it requires some level of peace. In a micro sense, processing a case, even if there's plea bargaining, but especially if there's a trial, that takes time. And then passing legislation, changing practices, transforming culture, that takes time. So how do, you know, we give people the patience? How do we make sure people have the patience to wait for those changes, hopefully peacefully, but protesting is very American. So we also need people speaking up to provide the impetus for those changes. So it's a very delicate balance. But I would suggest to you that there's a lot of discussion about law and order. It's really legitimacy that is the bridge between law and order. You can have all the laws in the world, but no order. If people believe the system is legitimate, they will wait for justice because they'll be confident that it's coming. So that's really what we need to focus on. And I believe legitimacy is the critical currency, more so than money, which is what, you know, a lot of the controversy has been around in the justice system. So let me also, I'm going to discuss a few different priorities, first relating to this restoring trust, building trust between police and communities, but then also talk about bail, fines, and fees, some of the legislation that was considered last session in Minnesota that I hope can be acted upon in your upcoming legislative session. But yeah, let me just first say that there is a real opportunity to build a bridge between police and community around this issue of shared vulnerability. And I've talked quite a bit about already the issues with individuals in the community who, whether it's because of a disability or otherwise, they're more vulnerable to the justice system. And because of a lack of resources, once they get into the system, it's much harder to get out. But I think we also have to look at the other side of the equation, which is police have a lot of vulnerabilities. I'm well aware of the issue of dozens of police officers in Minneapolis have left the force. Some are filing disability claims. And I read an article recently about an officer who was in the substation when it was it was under siege, basically, and he's had nightmares and PTSD and has filed for disability. And so some of you may be familiar with the Hope for Prisoners program in Las Vegas. And this is actually one where police officers act as mentors for people coming out of prison. And they've had tremendous success. It's headed by John Ponder, who was recognized at the White House. But one of the things that ties those officers to those people coming out of prison is they've been exposed to violence and trauma. Many of them also live in the same neighborhoods that are experiencing challenges. So when we can find those commonalities, we can begin to draw strength from them. And exposure to violence and trauma is actually one of the issues that has been correlated in academic research with officers more likely to use unnecessary force. So we have this huge opportunity, I think, to bridge this gap. And to say there are shared vulnerabilities both across the neighborhoods, the constituents, as well as with many of our police officers, and really bring us together and address those head on. So there are a number of steps we can take. I think the mayor talked about some of them in terms of improving training and de-escalation and communications between officers and communities. Some of you may be familiar with the Sandra Bland case from 2015 here in Texas, but you can watch the video on YouTube. You'll see that the officer escalated, raised his voice, was very hostile, and that ultimately resulted in a case that was a woman pulled over for failure to signal, ending up in jail and committing suicide. So there's so much we can do in terms of that. And I really think a lot of times we just talk about community policing, but it's really a matter of community engagement. And there's actually a lot of research on how we bridge divides even in our society that shows that doing things together actually is more impactful than just sitting around and talking about how we unify. And I think that's very much true here. And so to the extent officers and community can work in terms of things like removing graffiti, we saw in Los Angeles a recent study where officers assigned to public housing areas for a 5-year period built relationships with the community, crime went down, trust in police went up. A number of the Credible Messengers programs have shown great success as well. The mayor mentioned procedural justice, which is so important to recognize the agency of people we're dealing with in the system and really give them the opportunity to provide feedback as well. Co-responding, we've seen a great deal of success in that as well. Mobile mental health crisis units, Connecticut has 14 of those that they're able to address some calls through those with or without an officer. So these are some of the steps that we absolutely can take, I think, to really bridge that gap between police and community. Now, I wanted to also talk about some of the legislation in various areas. And again, I recognize the police bill, which was a good start that was passed in the last session there in Minnesota. But there were several other bills that were left on the table that I hope we can talk about. And I think that it's important for me to say that these issues really span the ideological divide. And so for if you're on the right, you certainly feel like we want to have limited government, and we want to apply the same skepticism to government action in this area as we do to being skeptical about, you know, whether a healthcare program that the government put in place is working, or any other program. So that lens of accountability is something that I think is one of the reasons why so many people on the right have embraced criminal justice reform as well. And of course, there's the issue of incarceration and how expensive it is. But I think it's important to say that saving money is really the appetizer. The main course is redemption. It's keeping families together. It's getting people reintegrated into the workforce. You know, the idea that people can change, which is the issue of redemption, that is something that appeals to people of every religious belief as well as no religious belief. And one of the issues that I think is also very important as we look to kind of build the political constituency for some of the reforms that I'm going to continue to talk about is these issues affect every community. We focus, sometimes we just focus entirely on urban areas like Minneapolis, but we also can look at smaller communities and rural communities. So for example, there's a lot of research showing that access to pretrial services, alternatives to money bail, are less common in rural areas, and pretrial detention is higher. Indigent defense is harder to access in rural areas. Policing, as far as crisis intervention services, smaller departments are less likely to have officers trained in crisis intervention. They're less likely to have officers with naloxone, the overdose reversal drug, in rural areas. So we have this tremendous opportunity, given the issues of overdose, of suicide, a lot of the issues plaguing our rural communities, to find common ground, and your legislature certainly is an excellent place to do that. And I also think one of the traditional divides between the right and the left that we have to, I think, really see as a false dichotomy is the idea of individual responsibility on one hand versus addressing the societal causes of crime. So some issues are fairly easy to see this, right? I mean, I read a recent article saying how Bloomington, Minnesota had street lighting that was well below state standards. And this is a fundamental thing. This is part of Mayor Eric Johnson's plan in Dallas to address crime. But it just goes to show, if you create an environment where people feel safer and it's easier to identify any threat, that is a societal intervention you can do, very basic things, street lighting, to reduce criminal activity. But more broadly, no one, of course, is born a criminal or born predisposed to criminal activity. How people are raised, what supports they have growing up plays a major role. And we know children of incarcerated parents, for example, are 6 times more likely to go to prison themselves. Now, on the other hand, none of that is to suggest people shouldn't be held accountable for their actions. So this is something that I think offers a chance to, again, find common ground and recognize we can have both accountability and a recognition that we have to address the societal causes of crime, as the mayor referenced as well. So let me talk about some of the legislation, first of all, relating to fines and fees, because again, this is an area where people who are poor face obstacles in the justice system. So there were 2 bills actually on this that didn't quite make it last time in Minnesota. One dealing with driver license revocation reform. That was House File 1061. And essentially what it said is, we're not going to suspend people's driver's licenses because they can't afford to pay fines and fees. And many states have done this in the last few years. And interestingly, what we were able to do in Texas is find that in a particular jurisdiction, San Antonio, that actually did this 7 or 8 years ago, they actually saw their revenues go up in terms of people paying fines. They put them on payment plans. And once people thought they could really do it, and again, they adjusted the fines based on ability to pay, which is very important. So it's achievable for someone, and also have community service as an option. But the bottom line is, if you take somebody's car away, take somebody's driver's license away, they're not going to be able to go to their job. They're less likely to be able to get basic needs met in our society, especially at a time when a lot of public transportation has been affected by the pandemic. So in New Jersey, a study found people whose driver's license was revoked were extremely likely to lose their job. And there's issues with people driving without insurance and the burden that places on other drivers. So this is just a common sense thing to do that I hope can be addressed next session in Minnesota, so you stop suspending people's driver's license because they can't pay fines or fees. Then there was also legislation on fines and fees reform, which would have said judges should waive or reduce fines or fees or substitute community service for people who don't have the wherewithal to pay those fines and fees. And I think it's very important how we define that. The Texas Supreme Court actually made a subtle but important change in that regard. So if somebody's got $500 in their bank account and their rent is $500, they don't have the ability to pay, right? So it's not just being completely indigent, but it's being able to not meet your basic needs and at the same time pay that fine or fee that should entitle someone to relief. Now, another issue that is very important for, and I know there'll be a panel on this later, but is bail reform. And the issue in Minnesota is essentially that the unaffordable bail, judges routinely set bail that they know that the person won't be able to pay. And in fact, that's the only way to keep somebody in jail pre-trial in Minnesota, because you don't have any form of preventive detention. There's a right to bail in the Constitution for every offense. And what I would suggest is taking a look at what New Jersey did a couple of years ago, which has been very successful. And they did a constitutional amendment to allow for preventive detention in certain circumstances, but they also said, basically, we're rarely going to use money bail, and if we do, it's going to be affordable, an amount somebody can pay without using a commercial bail bondsman. And they've had really strong success. They've reduced their jail populations by more than a third. The analysis that was published shows there's basically been the same level of people appearing in court. And they did a few things that I think are really important. First of all, of course, they do use a form of risk assessment that's been validated that doesn't use proxies for race or socioeconomic status. They put in $10 million in training and technology for judges. And of course, it's very important. I know there's a lot of controversy about risk assessment to say that it helps inform the judge's decision. It is not a substitute for that. And it's also important to take a look at what goes into that assessment. And I would recommend doing things like excluding prior drug possession offenses, because we know that falls heavily along racial lines. It's based on whether you live in a community where drug sales are likely to be policed, or whether you can afford to get drugs surreptitiously without a street corner, getting them on a street corner. So, and then also a number of assessments. It's important to distinguish between people who abscond, which basically is not showing up in court for months, versus someone who misses a court hearing. And actually, most of the research shows when someone misses a court hearing, most of those people end up showing up a week later. And so that really shouldn't count in the assessment. And by the way, there's some great apps now where people can say on the app, no, I'm not going to be able to make it tomorrow because of childcare, because of I'm sick. Instead of having to file something with the court, which is just so antiquated. We've got to make justice accessible. And by the way, during this pandemic, a number of jurisdictions have adopted remote pretrial hearings, where individuals can check in also with their probation officer remotely. And we've seen failures to appear go down dramatically with that, which kind of is a demonstration that a lot of the reason people weren't showing up before was in fact they didn't have transportation, they didn't have childcare, they were sick, et cetera. So the bail reform that was offered last session, House File 741, had a number of really good provisions in it, basically saying that the financial conditions cannot be such that they would result in someone staying in jail, which is essentially a requirement of affordable bail if you're going to use money at all. And again, the most important thing to remember is we have to make initially the decision whether somebody is too dangerous. And it's a very small category of people, so dangerous that they should stay in jail pre-trial, which is an exception from the norm. Chief Justice Rehnquist said in the Salerno opinion, the presumption in this country is a presumption of innocence, and the exception is pretrial detention. So if first you make the in-out decision, and then you move on to set the conditions. And certainly whether those should be that you ought to report to a pretrial services officer, you should post some collateral with the county. The evidence shows that for most people, financial conditions are not necessary and don't enhance the rate at which they'll appear. Things like text message reminders are very effective. I think there's rare white collar cases where, having somebody put their passport, give it to the county, right, is collateral. That makes a lot of sense. And actually it's wealthy people who are the ones who have the ability to flee the country, at least back when we were allowed to go to other places. So, that's something the bail reform is critical to look at. And then another part of that bill said if a defendant is in jail for more than 48 hours, the court must review the case more than 48 hours after a financial condition was set. And that's a safeguard there to say, oops, well, guess that bail amount was unaffordable if they're still there 48 hours later. So as far as the preventive detention net, it's important to carefully limit that, of course, to those offenses that are serious and people that are defendants that are assessed at a high risk level, particularly for a violent crime, and then have an instant expedited appeal going in front of all other cases, going up to your highest court. So somebody who has been denied bail, who has been preventively detained pursuant to that constitutional provision, can have that reviewed. And finally, there ought to be a requirement that not just probable cause, but clear and convincing evidence that they're actually guilty of what they've been arrested for. Because if you preventively detain somebody, we know it takes months many times, especially with the most serious cases, to resolve those. So you want to be very, very sure that that person is actually, if it's in the case of murder or rape that they've been arrested for, that they in fact are guilty of that. So then probation reform, which I'm really pleased that the 5-year cap was put in place by your sentencing commission, which really addressed some incredibly long probation terms in Minnesota that were well in excess of the national standard. And I think I often feel a little bit odd coming from Texas talking to you about criminal justice reform, since Minnesota has 7,900 people in prison. And even after our 20,000 decline in Texas since the pandemic started, we were off 15,000 before then. And now we've gone down another 20,000. But of course, we still have 120,000 people in prison. But the point is, in terms of probation, Minnesota was well out of whack, had a higher level than most other states in terms of people on probation. And that was really because of people being on for up to 40 years, which makes no sense at all. The academic research essentially shows that if somebody is compliant in their first couple of years on probation, they're highly unlikely to commit an offense, and you're wasting money supervising them when those officers could have lower caseloads and monitoring people who really need supervision. So one thing I would like to see is actually making that change retroactive, which the legislature could do, because you do have people that went on probation before that cap was put in place that have been on in some cases for decades, and it's totally unnecessary, and they ought to be taken off of probation absent some very, there's really no reason to have somebody on probation for 10 or 20 years. I know that issues are raised with sex offenders. Well, there's the sex offender registry, and that's a whole other can of worms, but there really is no benefit to keeping people on probation for decades. One of the innovations that I wanted to mention in the area of probation is something called dosage probation. And interestingly, Minnesota, Washington County is one of 2 counties that were part of the National Institute of Corrections trial on this. The other is Napa County in California. And essentially what this does is provide an ability for people to earn their way off of probation through exemplary conduct in roughly half the time that they might otherwise be on probation. And the court tells them at the beginning, here are your goals. Here's how many hours we want you to spend on treatment, for example. We want you to address through counseling things like antisocial attitudes, criminal thinking patterns. And if the individual is informed by the judge at the beginning, if you do those things, you put in that time, then you determine how long your probation is. You determine the dosage, and you can actually get off much sooner. And Washington County Attorney Pete Orput has basically said this has been very effective since it was started several years ago. And so I really think it's something we can expand on throughout Minnesota. One of the other innovations that we've seen, another very important area that I touched on at the beginning when it comes to equal access to justice, is indigent defense. And in Hennepin County, we've seen the use of holistic defense teams, where you have the defense counsel also assisted by a social worker, other staff that begin to address the underlying reasons why somebody got into the justice system while their case is still being handled, processed. And this is so important because what the average person doesn't realize is just how long, and this was true even before the pandemic backed up our system, but how long cases take to resolve. And a lot of people that come into the justice system, they have an urgent issue, whether it was an overdose, a mental health issue. And the defense counsel is actually in a place right at the beginning when they're assigned to the case to begin addressing those things. And that's the holistic defense model that you see with, for example, Bronx Defenders and Holistic Defense Team pilot program in Hennepin County. And I was actually told a story by a fellow named John Crusoe. He's now the district attorney in Dallas County, Texas, but before that he was working as defense counsel. Before that he was one of the first drug court judges in the country. But John told me, this was while he was representing, he said, I had a single mom who I was assigned by the court to represent, and she had a few kids, and she had a drug case, and she had a drug problem. And, I was able to arrange for her to get treatment. And meanwhile, this case is going on many months. And by the time we get to the end of it, she's clean, she's doing great, she's got her kid back. And now I'm sitting down with the prosecutor and telling this prosecutor she doesn't need a conviction. We've solved the problem. And ultimately he was able to prevail upon her. So that's not to give her a conviction. That really is what we can do through this holistic defense approach. So there was an evaluation published by the Bureau of Justice Assistance funded study, and it found in Hennepin County, these defense teams, the clients who received that type of representation on average had a 4-month shorter sentence, even if they were incarcerated, which shows you that again, they also use mitigation specialists, that they're really able to look at get them resources they need, and then when they are adjudicated, make sure the positive mitigating factors are brought to the court's attention. So a couple of other things I do want to touch on before I wrap up. One is ending juvenile life without parole. There was legislation offered, House File 1717 last session in Minnesota, and didn't advance. But in Ohio this year, I'm really happy to tell you, a bill, Senate Bill 156, passed 29-4 in the state Senate in Ohio. So it shows you the bipartisan appeal. And that particular bill would have provided an initial review in non-homicide cases at 18 and homicide cases at 25 years. So Minnesota still has juvenile life without parole on its books. Obviously, there's been a litany of Supreme Court decisions that have limited how that can be used. But I would suggest to you, regardless of whether you think it's cruel and unusual punishment, it's a terrible policy. You end up with somebody incarcerated at age 70 for something they did at 15 or 16, and at an expense of $3 million over that time frame. And the Philadelphia, the juvenile lifers that were recently resentenced there had a 1% recidivism rate. So it really is a smart thing to do. Now, I would be remiss if I didn't talk about medical conditional parole, especially given what's going on with COVID. As some of you may know, Minnesota is number 6 in COVID cases among incarcerated persons per capita. Sadly, number 3 for staff in our correctional institutions. Minnesota is number 3 per capita. In the Stillwater prison, 3 out of every 4 people who are incarcerated have COVID. So reached a very difficult situation, obviously for the our entire society, but people who are in prison are particularly vulnerable. Many of them have pre-existing medical conditions, which I talked about earlier. There have been 340 people in Minnesota who have been placed on conditional medical parole. That was much earlier in the pandemic. And I think it makes sense to continue to evaluate and identify people. I understand that there's a suggestion that more people would have been released, but have transitional housing. And I don't think that's a justifiable reason if somebody meets the other criteria in terms of public safety risk, that we ought to find them transitional housing. And it could be through housing vouchers, for example, for people that are seriously ill. There could be a hospice or nursing home environment. But we ought to really invest in those alternatives so people don't stay incarcerated simply because they don't have a suitable housing and reentry plan. One of the other things that's really important to look at is the diet people receive in prison. There's a lot of academic studies that have come out that vitamin D deficiency, which can be associated with a lack of sunlight, as well as a poor diet, that increases the morbidity associated with COVID. So I very much hope you can look at that. Two other issues, civil asset forfeiture reform. This is something that I very much hope Minnesota, and there were some changes over the last several years, but there was a bill offered last session, House File 4571, which would have made some really important changes. And this does link into everything else we've been talking about. Some of you, of course, I think all of you will remember the Eric Gardner case in New York City. And what of course, you remember he was suffocated to death for selling loose cigarettes outside a convenience store. But what you may not know is he was also a victim of civil asset forfeiture. And not only did police take, they just cleaned out his pockets, not only when he was selling loosies outside that convenience store, but they also cleaned out his pockets when he was dropping his kids off to school, when he was going to the grocery store. They just found him, walked up and took everything he had. And, you know, they assumed it was all proceeds from illegal activity, and maybe it was, but it's still a horrible thing to just hound somebody like that. And of course, going back to what I started with, civil asset forfeiture reform promotes distrust between the police and community, as do over-relying on fines and fees, and particularly the idea that the police and prosecutors, that they get money, that their budgets are tied to, in many places, how much money they collect through forfeiture, through fines and fees, and it creates that perception, this eat what you kill system. So it's unfair to police as well, by the way, because it puts them in a position that's unnecessarily adversarial and that's likely to result in negative. So in September of this year, there was a Minnesota auditor's report that I hope you'll take a look at on civil asset forfeiture, but it showed a majority of assets seized in Minnesota by police are worth less than $1,500. And the most common offenses that triggered that were driving with under the influence, drug possession. Actually, vehicles were 65% of the seizures. So again, of course, we ought to hold people accountable for drunk driving, right? But taking their car away is an extremely punitive step to take, and it often affects innocent owners. So a spouse who wasn't driving drunk, it may have been her car. Totally unfair especially when that car is titled to her. So what we need to do is actually do things to get people to stop being inebriated rather than, and again, we have ignition interlock, we have patches people can wear that detect alcohol in their system, 24/7 sobriety program, which has been very effective in South Dakota and other jurisdictions. So there's things we can do to make sure people are not driving drunk besides forever taking their car away, transferring title to the government. That's what we're talking about here. So that legislation had protections for innocent owners. It hearing, it established a $1,500 threshold for money and property. So we don't have these small dollar forfeitures, which affect people like Eric Gardner. And the cost to somebody to hire a lawyer to fight a forfeiture of a few $100s, it's prohibitive. So the government ends up keeping it by default, which is really unfair. Let me just conclude by saying that I think, you know, it's been a very challenging year for our entire society, both in terms of the pandemic and racial justice. And I think Minnesota offers an opportunity as of course, there were initial steps taken with that police reform bill to really provide an example to the rest of the country that we can, in fact, on what we have in common. We can bridge gaps between law enforcement and community. We can build a fairer system, one that doesn't just work for the people with the most resources, but a justice system that recognizes, because it's acting in all of our names, and the goal is justice, it can't just be one that gets fair outcomes for people that have a lot of money, for people that come into the system in perfect health. It has to be a system that really recognizes people come into it actually with more vulnerabilities than the average person in our society because of things that have happened to them in their life before that time. And we have to set about the task of really making sure that we set up all the procedures and processes in our justice system so that, yes, we have a single standard of laws. This is what's legal, this is what's illegal. But in the terms of how we enforce that, in terms of how we hold people accountable, it absolutely needs to be sensitive to the vulnerabilities that people have in our society and the experiences they've had leading up to their involvement in the justice system. So I hope all of you, I know you will, there's a tremendous agenda in this conference. We'll hear a lot of great ideas as the day goes on about how we can truly rise to this moment. So thanks so much for inviting me and look forward to the rest of the conference.